Okay, Whitman versus Green Tree Servicing.
Yes. Good afternoon, Your Honor. May it please the court. My name is Attorney Ivan Ivanov of Ivanov and Wolf, representing the appellant, Whitburn LLC. Way of background, this is a mortgage foreclosure. My client, Whitburn LLC, was a purchaser of a subject property in Hillsborough County prior to the bank's filing of the lawsuit. By now, the case law has very well settled that the pre-LP owner of a subject property can challenge standing as well as the amounts due and owing by virtue of its undisputed right of redemption, and I don't believe counsel will disagree with that. The issue that I'm here before this court today is very narrow. Whether or not the appellee bank was able to prove by sufficient evidence their ability to foreclose at the time of filing of the lawsuit as the holder. Holder is a statutorily defined term. Florida Statute 671.201 subsection 21 requires physical possession. A person alleging that they're the holder, as they have in their complaint, must have physical possession of the note. They have alleged they have physical possession. However, the certificate of possession that was executed by a third party to the lawsuit, a now defunct foreclosure mill, states as follows. It states Butler and Hash is in possession of the original promissory note. Let me repeat that. Butler and Hash is in possession of the original promissory note. Now, my argument here today is not that counsel cannot hold the original promissory note on behalf of its client. Of course they can. However, that ability, that agency relationship must be established by competent substantial evidence, and they have failed to do so here. Butler and Hash is not a party to the lawsuit. Now, 99% of the certificates of possession that I come across daily read as follows. Law firm ABC has been retained by the plaintiff to file this lawsuit. Law firm ABC is in possession of the original promissory note on behalf of the plaintiff. And then they show up with a Bailey letter at trial that is properly authenticated and admitted into evidence. Tie the dots, cross the T's, here's your agency relationship, and here are the documents to prove it. The law firm should be treated no different than a servicer, which I will discuss as to what this court has discussed in both the Cook and the Fan opinions as pertaining to a third-party servicer's ability to hold the original promissory note as an agent. By way of example, I represent as plaintiff's counsel hard money lenders in town and out of town, and I have at my office probably approximately 60 original promissory notes. What I do when a loan goes into default, again, I have a Bailey letter confirming receipt of the original, and I personally verify the possession of the original promissory note on behalf of my client, and I execute it, and I state the same. And again, when we go to summary judgment or when we go to trial, we present the Bailey letter, it gets properly authenticated. As we sit here today in this case, there was zero evidence, zero, that the purported plaintiff authorized the law firm, the foreclosure mill that went belly up of Butler and Hash, that they had the ability to hold the original promissory note on their behalf. To the contrary, the certificate of possession defeats their case that they're the holder. Butler and Hash was the holder, not Green Tree Servicing, which leads me to what was said by the sole witness that they presented. They could have subpoenaed the business records of Butler and Hash. They could have brought in the person who executed the verification on behalf of Butler and Hash. They didn't. They only had one witness at trial who stated the following. They had no documentation giving Butler and Hash the ability to hold the original promissory note on behalf of Green Tree. They had no Bailey letters evidencing that relationship, Green Tree and Butler and Hash, as pertaining to the original promissory note. Do you know on what date Butler and Hash received the original promissory note? I asked at trial. I don't have that in front of me, no. Do you know who delivered the original promissory note to Butler and Hash? I don't have that information with me today. Do you have any documents with you showing that Greentree physically delivered the original promissory note to Butler and Hash? I don't have that with me today. Do you have a representative from Butler and Hash to testify and confirm that agency relationship? No. The answer was no. Do you have any retainer agreements between Greentree and any counsel? I'm sure we do. I don't have it with me today. And the witness went on to state that she has never seen the original promissory note prior to trial. Let's talk about the two cases on which I am relying to, and those are two cases decided by the second DCA. It is the Cook case, 276 Southern 3rd, 472, in which the court discusses the third party's ability to hold the original on behalf of an alleged principal plaintiff as a purported agent. And this is in the context of a servicer. The Cook case, the Judge Sleet's opinion specifically discussed what the plaintiff did to prove that agency relationship, including, critically, the admission of Bailey letters at trial to reflect that the original note and mortgage were transferred from Entity A, the servicer, to the bank's attorney 2 months prior to the filing of the lawsuit. More importantly, the Cook case cites to a 4th DCA opinion of US Bank versus Angeloni, I apologize, which stands for the proposition that, and I quote, possession of a note by a third party, such as a servicer or a law firm, gives the owner of the note constructive possession sufficient to establish standing. And my argument here today is there is no evidence. They have failed to connect the dots. Just because you allege that you're counsel, you don't have carte blanche or a free pass to do anything on behalf of that client. Physical possession is required to prove standing as a holder by statute. Authority of counsel is not all-encompassing. This is no different than a servicer holding the note as an agent. Then the burden, again, the standard obviously is de novo as to sufficiency of evidence to prove standing. They have failed. Zero evidence that that law firm has the ability to hold the note on behalf of the plaintiff. To the contrary, the certificate of possession itself, well, obviously it's not into evidence, but more importantly, it says Butler and Hash has physical possession of the note. In the context of possession of an original document on which they rely to prove standing, they cannot, counsel of record cannot be treated, or original counsel, I should say, cannot be treated any different than an agent. All they had to do is show a Bailey letter. All they had to do is bring a witness to testify. Yes, we have a retainer agreement with these guys. It says that they can hold the note on our behalf, and they win. As to any sort of Ortiz presumption that I would expect counsel to rely on, it doesn't apply. It is my argument that it shouldn't, and it doesn't apply because a third party to the lawsuit, Butler and Hash, had physical possession of the note, and there was no evidence or testimony of record authorizing the third party to hold the note on behalf of the plaintiff. They still bear the burden of proving their case, of connecting the dots, of establishing standing as pled, as a holder. My affirmative defense on behalf of Whitburn is very specific, pointing out you can't be the holder because a third party to the note holds possession and there's no connection between a defunct foreclosure mill and the plaintiff. And obviously plaintiff is not the original payee. It is Bank of America. Thank you.
Good afternoon, Your Honors. May it please the court, William Noriega for the appellee. Briefly, I think the issues here that have been brought up by counsel are mainly focused on standing and what authority an agent has to hold on in the context of the Uniform Commercial Code to a negotiable instrument for purposes of showing standing. As counsel noted, we are afforded the Ortiz presumption in this case because there was a note endorsed in blank attached to the original complaint. that was later filed at trial in the substantially the exact same condition. Therefore, you have a presumption that there was standing at the beginning, inception of case, and as well at the time that the original note is surrendered with a blankly endorsed note. I think it's important to differentiate here that the comparisons between a servicer acting as agent versus an attorney acting as agent, there is a conclusive presumption, and I cited case law in my brief under the Chancellor case, a conclusive presumption that there is, that the law firm is acting with agency authority unless it's being challenged. It's a rebuttable presumption, but you have to introduce some sort of evidence of fraud or the law firm otherwise acting without agency authority, which wasn't done here. I think this is trying to be framed as one of your elements in establishing your foreclosure is you need to show the law firm's standing to bring this suit, when in actuality, I think that's confusing what the standing concept is. You know, when a law firm files suit on behalf of its client, there's a presumption, like I said, a conclusive presumption that that law firm is authorized to do so. And by virtue, that law firm is authorized as agent to hold that note. And again, looking at these cases that counsel cites, the Cook case and the Pham case, the Cook case, which was decided by this court, you know, when this court talks about the law firm having the Bailey letter, it's in the context of bolstering the fact that there was additional evidence, inference evidence that the servicer had authority and possession of the note to bring suit. It wasn't analyzed in the context of, well, we need to make sure that the law firm has authority to bring suit on behalf of the plaintiff. It's in the context of, here's additional evidence that the servicer was acting as agent of the plaintiff. So I believe that if you're going to look at the Cook case and the Pham case, you have to look at them for those in the context of what they're being decided. It wasn't being decided in the context of a law firm needs to show and prove up an agency relationship to the plaintiff if the law firm files a certificate of possession of a blankly endorsed instrument, because now you have an issue with constructive versus actual possession. Those cases narrowly talk about the firm having possession in the context of the servicer bringing suit on behalf of the plaintiff. And so for those reasons, I think the court must affirm, because it's just not part of plaintiff's prima facie case to show an agency relationship between the law firm filing suit and the plaintiff or servicer when it's bringing it on a holder theory. So I think I'll let my brief speak for itself for the remainder, unless the court has any further questions or follow-ups to the issues.
Thank you, Mr. Noriega. Mr. Ivanov, you didn't mention how much time you wanted for rebuttal, but why don't you take like 5 minutes if you want.
Sure, I will be very, very brief. Thank you, Your Honor. The cases cited by counsel in support of his position, well, the attorney can do pretty much anything bearing any fraud, are distinguishable. The Chancellor case to which he cites in his answer brief is distinguishable on the facts. It deals with whether a client authorized the attorney to represent him. Here, the argument is whether or not the law firm was an agent able to hold the original promissory note on behalf of the plaintiff. Because a certificate of possession, one, it's not into evidence, and two, a certificate of possession saying Butler and Hush holds the note doesn't get them there without any evidence. The evidence points out to a third party, Butler and Hush being the holder, technical holder at the time of filing of the lawsuit, with zero testimony and zero evidence connecting Butler and Hush and giving them the authority and the ability to hold the note on behalf of Green Tree. Thank you, Your Honor.
Thank you both very much. That's our last case on the docket today. So we are adjourned.
Thank you.